card for a parking problem.
And 423.
Yes, that's 4, I'll get a 28 from one truck when you're ready.
Go ahead.
From one truck, White Lincoln X-ray 985 should come back up next.
So you had 2000. Patrick Spalding.
10-4. If you can just put a little note in something like that, I'm going to be leaving a note on a vehicle and they can remove it.
Rockingham 505. 505 ended up vandalism case for Athens. Complainant, soon to be ex, slashed her tires and has made threatening comments to her. She's concerned he might return.
Yeah, forgive this at 32.
10-4. 532, you're assigned to a vandalism case in Athens. Did you copy the 505?
Yeah, 4.
21.
No, 3 in Depot Street. Truck boy entry 5.
7435.
10-4.
10-4.
You go 643 again.
143.
You go with that 43 you had. I didn't hear any, but I had just looks like we do.
10-4, I just wanted to know if you should be put back 76 to Cabana Circle or to the subject's address.
Yeah, I'll be 23 back on that town property case, and I'll be 76 to the Williams Road address to see if I can find the owner.
10-4. 449, 1120.
And 449, 1121, thank you.
10-4.
Code 4. 4.
Rockingham 535.
You have a great coach.
535.
You and me, you got no number of someone who fucked into a house. I'll slide up that way.
Caller is now been able to close the front door. He's now pounding on the door, trying to get it still. Now flight floor walking in here, got tie-dye shirt on. Number 21 is
We have separation. Inboard now. She's right. All right, good evening, guys. We got so much to go through today. So I'm hoping to have Kate on later. She's at a concert for her child today. And so I want to rush through things because so much has happened today that we have to get through. And you'll notice I've turned on the sign. So people that are smarter than me explained that if you have the room more lit up, that'll actually help make the sign stand out. So this is the dimmest it goes. That's a good start. We can see that much better. But in addition, just arriving today, based on someone else's suggestion, were these gel filters. Now, I haven't taken them out of the box yet. So it's a good start. We're already able to see the sign a little bit that was very nicely brought for me, but ordered by the dude abides. You guys all know the dude abides. So I will take a look at this film afterwards, and then I will probably add the gel to it, the gel filters to it. So it should look good. So again, everybody, thank you very much to the dude. All right. Just as always, I'm going to keep beginning with this. I'm going to make it really quick. The U.S. Attorney's Office, very uniquely, very strangely, under under then U.S. Attorney Josh Levy, actually questioned the witnesses in front of the federal grand jury. It's unheard of. Witnesses that were innocent, that are innocent people, that were not suspected of a crime. The only person that pointed to those people and said they were suspected in a crime was not the police, was not any prosecutor. It was a murder defendant. And based on that, this U.S. attorney, it was first U.S. attorney at that time, first assistant U.S. attorney, launched a massive federal investigation. And when it came time to the federal grand jury, he questioned witnesses himself on the stand, grilled them mercilessly, brought some to tears. Why? And strangely used Turtle Boy's blog as a blow-up, where the witnesses could see that. Unusual. But the oddest of all those things, Turtle Boy knows this and refuses to brag about it, refuses to even recognize it. What is going on? All right, let's leave that there. I want to address something else too. Please, I want people to understand. I try to accommodate, and I generally, as much as possible, cherish all the interaction between me and the other guests and chat. And I make it a point to stay on almost every show to answer questions until the questions are done. So I had 2 shows this week where I stayed on for 3.5 hours, 2 consecutive nights. And really the last hour of that was all answering questions. And I don't want sympathy, but I'm just want to explain that after about an hour, my back starts really causing me a lot of pain, and it keeps accelerating. So after a couple hours, I kind of don't really want to be sitting here, but I force myself to go through so I can answer questions. I do the best I can. It's imperfect. I understand that, but I do the best I can. The moderators here, I think it was Joe's idea, realized that maybe it was a good idea because people were frustrated that they couldn't get their questions seen, to put the question marks in front of it. And that was a great idea. The only problem with that now is it creates this idea with people, I guess, that I am automatically going to see every question just because it has a question mark next to it. Now, what people have to understand, I've explained it before, but I really need to understand. Maybe I'll take a screenshot and show it. Right now, I can see chat because we use an app called StreamYard. And in the StreamYard app, I can see on the right all of the chat. And I also have an option of clicking, if somebody makes a donation or something like that, I can click on that so I can see just those things. And and I answer those questions. And I try to pay attention as much to chat as I can, but it's also, that can be distracting if you just study chat, So, but what people have to understand most is that if I am going to a document or a message or a video, this StreamYard works in your browser. So what happens is I go to another tab. Now, I'm sure if I wanted to go through the effort of setting up a split screen or something, I could do that. But that gets a little bit distracting too, and it probably would be hard to see chat. So when I'm reading a document or looking at it or showing a video, and I I can't see anything in chat. So it wouldn't matter if you put 10 question marks in front of it and said, Kevin, look, there's a guy standing behind you with an axe. I wouldn't see it. There is no way I would see it. Because I'm in the other window, and that's just the reality of it. And then as soon as I come back into this, I go to chat and I do the best I can to get caught up. But I am not going to see everything that's in chat. And then sometimes during a hearing, there might be 700 people watching. And so chat's moving pretty fast. So I do my best and I stay on as long as I can. I just get a little upset if people are saying that I'm ignoring that, especially if it's someone that's kind of a friend or someone that's a regular. I would never do that. I would never do that. And I get frustrated that someone would think that I would, especially given people send me emails. I do my best to answer everyone. I certainly do my best to open and read everyone. There are times now I can't always answer it because they become kind of a flood. And I do read them all. And sometimes I just like if I might be doing something else or I might be on the phone, often with a source or the publisher or whatever, something. And not the publisher, but somebody connected to the book. And then the email comes across. So while I'm talking, I look at the email. But because I'm looking while I'm talking on the phone, I do read the email, but I may forget to respond later. I just doing the best I can to deal with this flood of information. I value everybody that's part of the community. I value respect. So I had somebody reach out again that was from the other side, but they said they respect the channel and they wanted to have civil discussions today. And I said, yes, that'd be great. And that's how it's always been. So I'm just one very flawed, imperfect person doing the best I can to deal with this, So I just want people to understand that. Just because you put question marks up, I do try to, that helps me see it. But I may not if the screen's moving fast, because I like to look in your eye too. And if I'm looking in your eye while I'm talking to you, I'm not looking at chat. But certainly if I'm in another tab, I can't even look at chat. It's not even an option. So please, I didn't mean to offend anybody the other day. I'd rather just hopefully move on for that. But I don't want anybody to think that I ignore chat, and I don't, or I ignore anybody in chat. Certainly not any of the regulars. I just would never do that. All right. So much has happened today. So much to go into. Don't even know where to start. Right. So I want to go first, though, to me, because this was something that I've known a lot about for a long time. So I always want to be as delicate as I can with all of this stuff too, and as respectful. So let me pull this up. So we got the motion, we got the denial of the motion to dismiss. And I'm not going to read the whole thing, even though it's actually fascinating. But there's some really, really interesting stuff in it. Since, for instance, we got the transcript of what happened in the sidebar when the juror was dismissed. All right, so we got it here late in the trial. All right. So let's see. Let me make sure I got the draft that I highlighted in. Yes. All right. So I'm going to spend a little more time on the other part of it, but let's just briefly go over the various aspects of this. So the first part of this motion to dismissal by the defense involved the Sally report. The judge points out that she's quoting from another case, dismissal of criminal charges with prejudice, meaning they can't bring it back to trial, is the most severe sanction that the court can impose in a criminal case to remedy misconduct on the part of the Commonwealth. That's what the defense is asking for. It was a Hail Mary. So that was never going to work. All right. So the Commonwealth had discovery obligations related to the Sally Port video. So let's see what the judge explains about it. The rule in effect at the time of discovery issues here provides that which means before the last trial, provides that the prosecution shall automatically disclose to the defense certain evidence relevant to the case and in the possession, custody, of control of the prosecutor, persons under the prosecutor's direction and control, or persons who have participated in investigating or evaluating the case. Any facts of an exculpatory nature and material and relevant police reports, photographs, tangible objects, all extended exhibits, blah, blah, blah. Those all have to be turned in as part of discovery. And potentially not turning in something like that, if you certainly if you can show any intent or even a pattern of it, could, depending on how material that evidence was, be the basis for a dismissal. But it would have to be pretty material. All right. So that materiality is just one aspect of it. All right. Factual background. And this is written by the judge. So according to the Commonwealth, surveillance footage from those cameras is automatically in the Sally Port is automatically overwritten on a regular basis. Footage from the night in question was not lost, however, because the Canton Police Department Sergeant DeCampetro followed his customary practice of downloading the recording to a hard drive in 6-hour segments. The lead investigator in the matter, Massachusetts State Police Trooper Michael Proctor, took possession of requested CPD video of the Sally Port in February of 2022. So that's right after John died, but did not turn it over to the prosecutors. Instead, for reasons unclear on the record, he kept the material in his case file. So I don't know if we'll ever know exactly what happened here. I think one thing to consider is at that time, that evidence would not have been considered material by Michael Proctor. Evidence of pulling the Lexus into the Sally Port would be no more material than evidence of them delivering John's clothing and the other evidence to the Attorney General's, to the District Attorney's office in the evidence room. It just was mundane stuff for them. So where that CD actually got stuck, was it when they say it's in the case file? Does that mean it's sitting in a folder inside the District Attorney's office where the detectives unit is? Was it handed over to one of the prosecutors, but they somehow put it in the wrong file? We don't know. On October 5th, 2022, this court issued an order directing the Commonwealth to provide the defense with all crime scene photographs, videos, basically crime scene photographs. But there's no, as we'll see, there's no reason to consider the Sally Port a crime scene. Even if the defense wants to argue that there was tampering that went on there, there's no reason for the prosecution or the investigators to have ever looked at the Sally Port as a crime scene location. All right, so several months later, in June of 2023, Proctor asked, so June of 2023, just to put things in focus, that's 2 months after the defense released its third-party culprit theory, its conspiracy theory, which accused Proctor and others of framing Karen. So at that time, so that's probably what prompted him to ask for video of the Sally Port. Proctor asked the CPD whether it had in its possession any you know what? I think I can make this a little bigger for you guys. Had in its possession any exterior Sally Port video showing the defendant's vehicle on the flatbed tow truck on January 29th. So in response, the Canton police gave the state police the video from the main driveway side exterior Sally Port camera. So there's different cameras set up here, and these are people in kind of an unusual situation trying to, what do we need here? What are we trying to prove? What are they looking for? So Proctor took possession of this video, but again, for reasons unexplained, did not turn it over to the prosecutors. So if you look at that in isolation, you say, wow, that's suspicious, right? Maybe that shows that the taillight was intact. Well, guess again. Instead, he placed it in the case file. This footage shows the exterior of the Sally Port when the defendant's vehicle was brought to the garage. The recording is dark, blurry, and grainy, and the condition of the passenger side taillight, a significant issue in dispute in the case, cannot be discerned. That's from the judge. Okay, so this video was not going to be exculpatory to Karen, or in any way, or inculpatory. So, for instance, had the video been clear, it would have helped the prosecution, right? Because it would have proved that the taillight was intact. I'm sorry, the taillight was missing pieces. So this video could have helped either side, but it just wasn't clear. It's surveillance video, and it's probably old and outdated system at the Canton Police Station. This is, it's not the FBI. All right. So on February 1st, 2024, Proctor testified before a federal grand jury. 3 months later, on April 4th, Adam Lally received Proctor's federal grand jury testimony. Okay, so he didn't get this until April 4th. After reading Proctor's testimony, Lally asked the trooper if he was in possession of the video footage referenced therein. So Proctor, under questioning in the federal grand jury, at some point mentioned having this Sallyport video. In response, Proctor gave Lally the Sallyport front wall camera footage provided to Proctor in February of 2022, but not the main driveway side exterior Sallyport footage provided to Proctor in June. So it sounds a little Keystone Cop-ish here, but if I was an investigator, that's how it would be too. I mean, I'm very disorganized with stuff like this, but they need to have a better system. But again, we'll see that none of it is really material either. Lally immediately turned over the Sallyport front wall camera footage to the defense, along with footage from the CPD main driveway, showing the SUV on the flatbed. None of this footage contained a view of the back of the defendant's SUV. So again, none of that footage was really useful other than to show what time the tow truck arrived. And so we know that now, that it was at 5:31. And that's too late to get pieces to the crime scene if you're going to tamper with it there. All right. On April 10th, 2024, Lally filed a certificate of compliance indicating that to the best of their knowledge, they had disclosed and made available all items. But when defense counsel reviewed the Sallyport front wall camera footage, they saw 42 minutes of what they call missing. This is, again, the games that they play. And they would tell this to Nick, and he goes to court TV and says, oh, there's 42 minutes missing. Well, it's just like with the library video. And again, this is why we in the public need to grow a sense of common skepticism and common sense. And I needed to grow it too, right? So in the summer of 2023, as Turtle Boy was first pushing the defense conspiracy theory and pushing a lot of things that have since been debunked or explained away, one of them was the gap, the so-called gap in the library video. They dramatically in a hearing, Alan Jackson claimed that there was a gap in the video, and I think the time they gave was 12:37 to 12:39 or something like that, or 12:35 to 12:37. I forget exactly what it was. Even the time they gave doesn't make sense because we now know what time Karen got home. At least what time her phone automatically connected to John's Wi-Fi, which was around 12:36. So, but there was never a gap. A gap implies something was deleted, like the Nixon Watergate tapes. No. And once I remember that summer, I did a video called The Mysterious Gap in the library video, because I thought it was suspicious too. I was an idiot. I had skepticism about defense claims, but I hadn't figured out the explanation. And maybe I was being too exploitive at the time too, and trying to exploit the public thirst for conspiracy. So the gap is explained very simply in the library gap. It's a motion-triggered video camera, like all video cameras pretty much are now, right? Your Ring camera. These things are all motion-triggered. So what he calls a gap really just means nobody drove by the library at that time. All right, well, the same thing applies to this missing 42 minutes. The Commonwealth explained that the footage was intermittent because the camera was motion activated. So I don't know. I don't know if that fully explains it or not, because I know inside the Sallyport, I don't know where that, there was motion, right? Because there was guys walking around in there. So whether that fully explains it, I don't know. It seemed to, but it explained it enough to the judge. And it may just be combination of All right, so you know all these cameras have settings, and this system in the Sally Port was clearly old. So your camera settings are designed to pick up certain things. Maybe this was just designed to be when somebody drove in a vehicle. I really don't know the full explanation. But because of this claim of a gap, it caused the prosecution to go look and see if there was more. All right, let me roll down. On April 17th, now, Lally received footage of the Sally Port interior back wall camera. So another camera, which had been looking for continuous camera footage of the Sally Port on the relevant date. On April 23rd, he provided the Sally Port interior back wall footage to the defense. The images contained in that footage were inverted, as we all know. Interestingly enough, so when I look on my screen at this Yellow Cottage Tales sign behind me, it's inverted on my screen. That's so there's a process where it's recorded inverted, but then by the time it gets to you, it's not inverted. So there's complicated stuff that goes on. I don't know the technical reasons why. Thomas Fleming can maybe explain that better to you. He was the one that first explained it to me back during the trial because he had studied this stuff. And maybe we don't need to know the technical reasons. I guess they've been even built old cameras before the digital age with a mirror inside it to invert it. So there are technical reasons for this, but all you really need to know is it's normal. You know, it seemed weird to us at the time, but it turns out it's normal. All right. So continuing on, because the video was inverted, what appeared on screen as the right side of the vehicle was in fact on the left side. Right. We got that. The direct testimony did not alert the jury that the video was inverted. On cross-examination, however, defense counsel questioned Buchanan. So they figured it out over the weekend, and obviously it wasn't intentional. And there's no way that it was intentional because it was easy to figure out. Obviously, Buchanan wasn't able to do it watching it, although he kind of knew something was wrong because you could tell in his mind, he's like, I think that's coming in the wrong side, you know? And Lowy didn't notice it. Lowy has had a million things to do, but they weren't going to sneak it through because people in the public were going to see that the sign on the number on the bay door was still inverted and the logo on the other the classic police car that was in there was inverted. So and now the prosecution has submitted evidence taken from that same camera from a month before, and sure enough, it also plays as inverted. So it's another non-scandal here, and we just, as you'll see, this defense gets to present these endlessly, and so many people on that side. And we're going to go over a new Vanity Fair article that's an interview with the alternate juror. And so we got stuff tonight on the alternate juror and on the dismissed juror, which are two different people. And that's Grant Smith got this confused earlier, but they're two different people and they're two different. It's understandable to confuse it, but they're different. They're incidents. They're different incidents. All right. The CPD began a review of the other video surveillance footage in an attempt to explain the inverted image and to respond to allegations. All right. So that's what I just explained, that they got footage from another date to show it. Also, the judge notes that the rear lot cruiser side camera, so that's the parking lot, had recorded. So there's a parking lot behind the building, and that's where the police cruisers are parked. And that's also where Higgins had his private vehicles there, or his government-issued vehicles there, and had to move them because there was an incoming blizzard, and the parking lot was going to be plowed. So they would have to move them for that. All right. It had recorded ATF agent Brian Higgins, a witness called by the Commonwealth at the trial, walking across the parking lot at 1:34 a.m., holding a phone near his face. The people in the Free Karen Reed Road are flipping over that, like saying, why can't she say that he was on the phone? Because obviously, it's amazing the stuff that's not obvious to these people. Judge Cannoni looking at a video showing showing him with his phone to his face. She can't tell that he's on the phone. He could be listening to a song that was recorded, that he downloaded earlier. Now, I'm sure he wasn't. But she's describing it accurately. All she knows from looking at this soundless video is that he's got a phone near his face, and they have a problem with that. It's unbelievable. All right. So in September 24, now Prosecutor Brennan is on the team, and in October, he reviewed this rear lot cruiser footage. And he made this video available to the defense on November 8th. The defense emailed Special Prosecutor Brennan requesting all raw video from the CPD, which shall include, but is not limited to, all cameras capturing the interior of the CPD and the exterior of the CPD, including all parking areas, entrance and exits, and garages between January 29th at 12 a.m. and January 29th at 11:59 p.m. I don't know. That's an oddly worded way. But anyways, all right. So Special Prosecutor Brennan responded that he would request that the CPD collect and produce all footage responsive to the request. Let me take these off. They make me get hot. I'll put them on after if Kate comes on. So, and I've also invited Daniel and Matt in case they want to come on. They see enough of me during the week, so they probably won't. But I talked to Kate. I think she'll be on. All right. So during this process, Brennan came into possession of the main driveway side exterior Sallyport footage originally obtained by Proctor in June of 23 and not previously turned over to the defense. We already know the defense's arguments. And here's the judge's reply. First, contrary to the defendant's argument, there was no court order requiring that the Commonwealth to preserve or produce the CPD surveillance video before the first trial. So the only order from the defense on that was this past December, after they were learning there might still be more, and they reached out to Hank Brennan and gave that order to preserve anything else, which he has diligently tried to provide them immediately, everything that they get. All right. The February 2nd, 2022 preservation order, so the old one originally issued by Yannetti a couple of days after John died, required the Commonwealth to preserve all physical evidence, including anything present on or near the decedent at the time his body was discovered, anything found at the alleged crime scene. So the defense, again, it's so shady what they do. So the defense tried to say that these Sallyport videos were covered by that original order because that's a crime scene. It doesn't even pass the smell test. This order says at or it's anything present on or near John's body when it was discovered, or anything found at the alleged crime scene. Clearly, to any person with a brain, even a free Karen Reed person, the alleged crime scene was 34 Fairview. Certainly when Yannetti wrote that up, he was not thinking of the Sallyport. It's just stunning to me, the stuff that people get to say, or the defense gets to say, and everybody just nods along. It's unbelievable. All right. On October 5th, 2022, order on the motion to compel discovery also did not require the Commonwealth to produce any CPD surveillance video. Of course it didn't. The order required the prosecution to produce evidence of all crime. So the judge is explaining what I just said. This is not the end of the inquiry, however. The absence of court order, so this is important. Just because Yannetti did not include that in his first court order does not completely mean the state doesn't have to provide stuff. The absence of a court order requiring production of the CPD surveillance does not foreclose the ability that production may still have required under Brady. So the Brady versus Maryland is anything that's exculpatory. So if that evidence was exculpatory to Karen, then the state would still have to. State would still have to provide it. Assuming, without deciding that the footage is actually useful to the defense. So the judge is not going to make a decision on whether it was useful, because she heard Hank Brennan's arguments that there was no time to get those, to tamper with the vehicle inside the Sally port, and there was no evidence that it was tampered in there. But she says, assuming without deciding that the footage is actually useful to the defense, dismissal is not warranted because defense counsel actually used this evidence to advance the tampering theory at the first trial and can do so again at the retrial. So the evidence that was produced before the first trial in April, so it was late, but it was produced, was used by the defense, and none of the new evidence that has come out is actually enhances anything that any of the argument that they made before. There's no new smoking gun or damaging evidence. They've tried to point the fact that Higgins is on the phone. That's not proof of anything. That's ridiculous. No idea what he was calling, and it does at 12:34, and it doesn't matter. It's his business. All right. In addition, with the current Rule 14 makes clear that the Commonwealth is required to disclose to defense is investigative materials, video and audio recordings in the possession, custody, or control of any member of the prosecuting team. So I guess the distinction here would be if it's in the hands of the investigator and the prosecution isn't aware of it, then that part doesn't apply to them. It doesn't eliminate this problem, but it weakens it. All right. So in effect, at the time, clearly state the Rule 14 in effect at the time clearly state that the prosecutor's duty to inquire whether such evidence exists because the defendant made no specific request of the Commonwealth to produce such evidence until after the first trial. It is not clear on the record how or when the Commonwealth should have known that the surveillance video was germane to the defense. Until the Commonwealth knew, for example, that the defense theory included that law enforcement tampered with the taillight while it was at the Sally port, or that Higgins was a proposed third-party culprit, it had no reason to inquire as to whether any relevant video footage existed. This is not to say that the Commonwealth had no duty to turn over the Sally port interior back wall footage before the first trial. The production during trial was undoubtedly late. However, the defendant received the video more than a month before it was submitted into evidence. And because she has advanced no argument as to what, if anything, her counsel would have done differently if the disclosure had come earlier, the defendant has not shown she was prejudiced as a result of the late disclosure. So that's a key point. So basically what the defense has here is this outwardly troubling pattern of getting evidence late and getting some evidence after the trial. But they have not shown that Karen was damaged by any of that, and that's important. So if you're going to go to the extreme measure of throwing the case out of court and letting a murder defendant go free without a trial, you have to have stronger stuff than what the defense has presented. All right. So, and also another footnote here with respect to the main driveway side exterior Sally port camera, even if Proctor should have turned it over to Lally prior to the trial, the quality of the footage is so poor that it is impossible to tell the condition of the taillight or how close anyone was to the right taillight. I also just want to mention real quickly here, but just because it popped into my mind. So Turtle Boy posted today, if anybody has video of Plevin claiming to have communicated with the DA's office, please send it to me. I've never communicated, even indirectly, with anybody from the district attorney's office. No smoke signals, no text messages, no emails, no communications through a third party. Never. I'm a cautious guy. So even back when Sean first sent me images of the Sally port that showed the taillight, I didn't know what to do. I didn't want them on my phone. I knew they had to be discovery material. I didn't send them to anybody. I didn't show them on this phone. So I didn't delete the messages. I just didn't know what to do. I've been very cautious about anything like that, and no one has ever tried to give me discovery information other than that. The only other thing, so one day, this was back in, I think, September, or maybe probably September of 2023, I got a Facebook message from someone that I had never communicated with before and didn't know. And in this message was 2 audio files. And when they came, I listened to them not really knowing what it was. But then as I listened, I was like, oh, this must be Scanlon. But again, it was the same thing. I didn't know. Was this discovery material? At the time it wasn't. I think it might be now. If Turtle Boy picked up wiretap charges on this. But I was so reluctant to get anything that might be of evidence for something. I didn't forward those to anybody either. I didn't play them on the channel. I didn't do anything with them. And those are the only things anybody's ever sent me. I've never been sent anything else. So, that's it. I've definitely never had any communications with anybody from the DA's office. All right. The defendant also argues that the Commonwealth has violated Rule 14 by failing to preserve all the footage with the metadata. So this is the stuff that would show when it was recorded, if there were deletions, all that stuff. All right. There is no merit to this argument. The defendant did not make any specific requests for the original footage with the metadata before the first trial, before it was overwritten. Because once it's overwritten, I know I'm not a tech person on this stuff. There is nothing in the version of Rule 14 then in effect, or in the current version, that entitles the defendant to the metadata or log files underpinning surveillance footage in the possession of the Commonwealth, and the defendant has not directed this court to any authority suggesting preservation of such evidence is required. Nor has the defendant demonstrated that the metadata would have been exculpatory. So it's they're going on a fishing expedition to see if some video was deleted, right? And but they have no evidence that was. There's no. So for instance, you could, in theory, have had this applied to the Ring video. You could say, well, we know that there's missing video for the Ring video because we know Karen got home and that's missing, and we know Karen and Jen and Kerry went out again and that's missing. So you can infer from that somebody deleted those videos. All right. Nor has the defendant demonstrated that the metadata would have been exculpatory. No, she offers no evidentiary support for the argument that the metadata would confirm her theory that members of the CPD or state police doctored the footage to prevent jurors from seeing the condition of the defendant's taillight before it was within the custody. I mean, I just don't understand how people don't have a sense of skepticism about what any defense team tells them, and sometimes a prosecution team. But in every single murder case that will ever exist since Cain and Abel, every murder case, if Cain and what was it, Cain that killed Abel? If Cain has had a lawyer in the trial, all the way back in the Old Testament, that lawyer was going to try to distort things. That's their job, right? In order to create reasonable doubt. So people have to have the common sense to understand that that's how the process works. So if you are on trial for murder or on some big thing like that, and you hire a defense lawyer, which you will, and that defense lawyer is not going out of their way to make mundane things seem unusual, well, they might not be doing their job. So you should probably get another one. I mean, but we in the public have to understand that's what they do. That's their job. It's our job not to be so goddamn easily fooled. All right. The next thing was the exculpatory statement by Jennifer McCabe. So Jennifer McCabe, at some point, the defense found data. I think Rich Green found it that Jen the next day had gone, by tracking the GPS on her phone, that she had gone to Officer Lank's house. And so she was asked before her testimony by Lieutenant Tully, as part of her preparation, if she had gone to Lank's house or if she had gone anywhere. I forget. We'll see. I think they'll. All right. So during the trial, Lieutenant Tully interviewed Jen McCabe, apparently had a full interview with her. He took a report, dated the report, and then held on to that report until after she testified. So that is a little shady. No question about it if it was done on purpose, and it seems like maybe it was. But we'll see why this is not actually, though it might be a little shady, it's nowhere near enough to result in a dismissal. The interview, the report, and the completion of the report were all done before her testimony. So what the defense is saying is we should have had that report so we could have used that to impeach Jen McCabe on the stand, impeach her testimony. All right. And there's no indication that Jen McCabe did anything wrong. It's a little bit shady just that the defense, I'm sorry, that Lieutenant Tully didn't provide that report to, it sounds like he didn't provide it to the prosecution until after Jen testified and then didn't provide it to the defense team, which is kind of as shady. That's a milder but shady like what the defense does. So, but we'll see why the judge says this was not a problem, and it's Alan Jackson's own words that sinks him. All right, the Commonwealth therefore should have provided Jen's statement to the defendant after meeting with her, and certainly before her testimony. However, the defendant cannot reasonably claim that she suffered any prejudice as a result of not having Jen's statement. This is why, on cross-examination, Jackson questioned McCabe extensively about what she had told Lieutenant Tully about her visit to Lang's house, why she had not disclosed such events before, and the details of her visit to the house. So they got to talk about it anyways. And moreover, but this is the big one, Jackson expressed satisfaction with the damage he believed he had inflicted on McCabe's credibility. So Jackson really messed up here. I remember that moment in court when he tried to bring it up. And the judge said, do you want to put Jen McCabe back on the stand? Because this was after they had got the notes. And Alan Jackson understandably expressed his frustration, but he made a mistake in what his reply was, and the judge exploited it here. When he declined the court's invitation to recall Jen McCabe to the witness stand in this manner, Jackson undermined any newfound claim of prejudice based on the late disclosure. And once again, the remedy for a violation, I might have already skipped over that part where Jackson replied. Let me go back. Anyway, maybe I just didn't get to it yet. All right. Because what happened was Jen McCabe said, Alan Jackson said, no, that would not, when the judge offered to put her back on the stand, Alan Jackson said, no, that's not necessary because I've already done my damage. So you can't really prove that Karen's case was harmed by her inability to impeach Jen McCabe's credibility based on that questioning when her own lawyer in the trial, when offered to put her up on the stand again, not only says no, but says, I've already done the damage. So he's already done the damage. So how much, what else could he do to her, right? So in his opinion. So he screwed them with that, Alan Jackson. So the judge comments that dismissal with prejudice is too drastic a remedy if the error can be remedied and the defendant can still obtain a fair trial. Indeed, even in cases where the withholding of evidence is brought to light after a conviction, the remedy is most often a new trial, not dismissal of the charges. So even if you could show that there was some prejudice against Karen, this is maybe a little bit of a dubious point, though. So, all right, so let's say Karen had been convicted, and then they could show that there was a problem here, but because this evidence was withheld. The solution would not be for Karen to have the charges dismissed. The solution would be a new trial, right? So that's an interesting point. But, the defense could also maybe counter with that had they been allowed to do that, they maybe would have gotten acquittal, and maybe they had a better chance to get an acquittal the first time than the second time. I don't know. I think the judge is correct here, but nor has the defendant shown the Commonwealth's conduct was so egregious, deliberate, and intentional that prejudice should be presumed. Such a theory should be narrowly, wow, that's a tough word, narrowly applied and confined to situations where that misconduct has cast such doubt as to poison the entire investigation, and a stronger deterrent is warranted to prevent repetition of such misconduct. So the dismissal of these charges would be outlandish. There's, there's no evidence that Jen McCabe committed a crime. lied about anything significant. There is an incredible mountain of evidence that shows that Karen's Lexus struck John. So to throw it out because of something like that would be out of proportion. All right. The facts before the court do not depict a concerted and intentional attempt by the prosecution team to deprive the defendant of discovery. All right. So before I get to the Massachusetts State Police interference with the jury, just want to briefly mention the book. So the book is now, you can order a paperback and a hard copy. Let me get this link for you. Sorry about the little feedback loop there. I had to pull into this to get the link. All right. So the Audible is still not complete yet. That should be up by next week. But you can order the hardcover or the paperback. And I don't set the prices. I apologize if it seems a little expensive, but that may be just because I'm old and I don't know what book costs anymore. All right. So I just put the link in there. But I'm sure if you want a discounted version of it, just wait until it's after it's out for a couple weeks. But if you don't mind supporting it now, then feel free to order and get the paperback or the hardcover. And the Audible will be out probably next week, I would say. So thank you for the support on that. It's gone down a little bit in the rankings, understandably, because most of the people that know us gave that support in the first night. So it is on Amazon. So that link that I just put in, Maureen, I'll put it in again. That link right there, I don't know how to make it so it shows as a link. But also, if you go to the description of this video on YouTube, you'll see the link there. Or if you just go to Amazon and search for Storm of Suspicion, Noam Nixon says the book sucks, but the book hasn't been released yet, dude. So you reveal yourself. The book hasn't. All you can do is pre-order the book, so you have no idea if the book sucks. But that's what free Karen Read people are like. That's how you guys roll. Always, just always outing yourself as what you are. All right. So again, thank you for the support. All right, let's go back to the document. All right. So now again, there are two issues with jurors here. There is the dismissed juror that we're going to discuss here, but there's another thing that's come up today, and we're going to go to an article with this. But so there's the dismissed juror. There was a juror. She's called Juror A here, by the judge. And she was dismissed for inappropriate activity right before the start of deliberations. But there was also an alternate juror. The alternate juror, when the sides end their closing arguments and it's about to begin to determine. So at this point, they've got 14 jurors left. I think 2 had been dismissed, so they started with 16. Now 14 were left. But now you've got to get it down to 12. So the other 2 jurors become alternates, and they select it from lottery. The 2 alternates are still required to go to court, and they may still have to ultimately deliberate. So they stay out of the deliberation room. But if somebody that's on the deliberating jury gets ill and has to leave, then that alternate juror comes back on duty, and they start deliberating from scratch. So they're still required to go to court. Well, when this juror was made the alternate, she showed up the next day crying and wearing a pink dress. And it turns out she's a lawyer. She's in close touch with Turtle Boy. When Turtle Boy interviewed Ronnie, one of the other jurors on his show a few weeks ago, she was texting him questions to ask. So they've obviously got a close communication, which is all these are troubling signs, right? But she's a lawyer, and now in this really strange, bizarre world of Karen Reed, now she's been added to Karen's defense team, if you can believe this. So Karen's defense team now has a lawyer that was on the jury last time, and that became an alternate jury. No one has ever heard of anything like this. I saw Martha Coakley, former attorney general in Boston, talking about this on Channel 5. She said she never heard of anything about like this. But apparently there's no rule against it. So actually, I think it's pretty clever of the defense. But what bothers me is the other implications. Why are these jurors reaching as soon as the trial is over, and hopefully not before that? Why are they reaching out to Turtle Boy? I mean, there's so many other media sources you could reach out to. And there's even bloggers and YouTubers that have pretty substantial support, substantial followings. Like the lawyer, that guy, his channel gets an audience that's multiple times larger than Turtle Boy's. Why not go reach out to him? Why do they reach out to Turtle Boy? Why not reach out to the goddamn Glare or Young Jelly? You're reaching out to a guy who is trying to dox the jury foreman, who is doxing the jury foreman, who has threatened any juror that doesn't vote his way. Don't you have any sense of loyalty to those people that you served those 10 weeks with? Well, it seems that none of these pink-shirted jurors do. So the dismissed juror is in close contact with Turtle Boy. I know that for a fact. Trust me. The alternate juror is in close contact with Turtle Boy. Ronnie is obviously in close contact with Turtle Boy. I'm not sure if there's any others, but, none of these people have reached out to the lawyer, right? They're not reaching out to Melanie Little. They're reaching out to a scumbag who is threatening to bring a mob to the kids' soccer games of the Attorney General. A guy who's doing those kind of things pretty much every day and certainly every week. There's no way that they could be unaware of what he is. And they're going to go to him? That tells me a lot. See, the problem is that tells me a lot about those jurors. That tells me a lot about them. It tells me they would probably free Karen Reed when they got on the jury. But we're going to see a little bit more about that because we have an interview from this alternate juror who is now on the defense team. And somebody raises a very good point as to whether the gag order applies to her. So that's pretty interesting. Let's see. And I also had an interesting message earlier from Claire Marie. You've seen Claire Marie in chat. And she was wondering if the fact that the ARCA guys seem to be only interested in the idea that John threw the cocktail glass at the taillight, where did they get that idea? Is it possible that the feds gave them that idea? And if they did, where did they get the idea? And she says at the very beginning, Karen was basically confessing to Yannetti that she may have mentioned having a memory of John throwing the glass or hearing it hit the car. And see, I'm not even, where is that? Don't recall, that's a really interesting point, and I don't recall that, Claire Marie. So I'd like to know where where did Kerry basically confess to Yannetti that she may have mentioned having a memory of John throwing the glass? Please send me a message as to where that is from, because I don't know. Is that from the Ted Daniels interview? Is that from the documentary or from the Vanity Fair article? That is a really, really interesting point, Claire Marie. So very good observation. And please, I am reading a document now, so I don't see anything in chat. I don't even see the chat window. All right. So if you can remember where it's from, and if you're watching today, send me an email on that. So thank you. All right. So let's go to this is going to be a discussion in this. So the defense tried to one of the they had three parts to argue dismissal of the case. One was the Sally Port video, and the irregular releasing of it. 2 was Lieutenant Tully not revealing that he had until too late his interview of Jen McCabe. And 3 was the juror dismissed, who they say, and rightly so, was pro Karen. And they believe it was some kind of conspiracy by the state police to get rid of this juror because they had observed her facial expressions as being pro Karen. All right. So not at all. And I'm not going to go into more details than I need to, but let's try to stick as much as possible. You guys know I know a lot about this, but try to stick to what the judge said here, and there is some new information. All right. So during trial, 2 issues arose with the jurors. This is the judge speaking. The first occurred on June 14th when one juror, Juror A, reported to the court that another juror, Juror B, had made some comments about the evidence and the defendant. The court called Juror A ratted on Juror B and said that Juror B doesn't like Karen. The court called Juror B to sidebar and questioned her about what she had said and if she could keep an open mind and consider the evidence in a fair and impartial manner. Despite her representations that she could, the defense understandably expressed concern that the comments had been one-sided and against the defense and asked that Juror B be excluded. The court then inquired of Juror A. Now, Juror A will come up again because she's ultimately the one that got dismissed. She's the second one that got dismissed. So Juror A stated that Juror B had made comments to her about the defendant's facial expressions during the trial. The court then questioned 2 other jurors whom Juror A said were sitting closely by when Juror B made those comments. But both jurors stated that they had not heard what Juror B said directly, but that Juror A had mentioned it to him. So this Juror A is really trying to sabotage the state's trial here. To me, I mean, we'll see when we see. All right, based on this alone, we don't know that. But looking at this in the context of what we're going to learn later about what Juror A did, it was very disturbing. So Juror B apparently was watching, if Juror A is telling the truth, that was bothered by Karen's very unusual facial expressions in court, which everybody was, right? But it would be inappropriate if Juror B did say something like that, even though very understandable if she felt that way. Everybody in the world watching Karen feels that way. Even Turtle Boy saying that now, So the other 2 jurors that they talked to did not hear Juror B say those comments. So the only person that heard Juror B make these comments about Karen's facial expressions was Juror A, who we're going to find out is a turtle rider. All right. Now, what the other 2 jurors did hear was Juror A telling them that Juror B didn't like Karen or didn't like her facial reactions. So the court then called back Juror B, who denied making any negative comments about the defendant. After questioning the jurors, the court consulted with counsel. The Commonwealth expressed that if the court struck Juror B, it should also. So the state's position was, well, if you're going to strike Juror B, you should strike Juror A. That's a valid point. I don't know. The defense disagreed. The court ultimately decided to dismiss just Juror B. So Juror A successfully managed to dismiss someone that, in her opinion, didn't like Karen. So she's kind of operating like a Karen agent on the jury. All right. So on June 25th, now again, I say that only knowing other stuff that I know. Without knowing that, looking at it in isolation, it's harder. I don't know why the judge would ultimately take one juror's word over the other. That's a problem. But I think the judge was in a hard situation. So you've got at that point, they were down to, they had 16 jurors at that point. So if they dismissed this Juror B, there's still 15, still a surplus of 3. So she was probably just erring on the side of caution. All right. On June 25th, so this is a few weeks later, just before closing arguments were scheduled to take place, the court received information from court security, which is we have separation of branches. So the police operate under the executive branch. The prosecution operates under the executive branch. Court security, however, operates under the court's control. So they're part of the judicial branch. So the court received information from court security, the court meaning the judge, from court security from another case involving dun 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 juror A, of course. A member of the Massachusetts State Police had contacted court security and said that he received information that a juror thought to be juror A was at one of the local posts for the American Legion talking about the case and that there might be a recording of her doing so. At roll call for the Dedham Police on that morning, a number of officers confirmed that they had heard similar things about the juror. The court called a sidebar to discuss this new information with the attorneys. Defense counsel asked for the name of the Massachusetts State Police officer that received the information. So they're trying to cast doubt about it. And it was Lieutenant Fanning. He's never stepped inside the courthouse, has never encountered any of the jurors. He's in charge of, I don't know how many troops, but it had to be probably 20 troopers that are assigned to security out there because of that massive, unruly Karen Reed mob. And there were no, at that time, any blue protesters, so it was 100% Karen Reed crowd out there. And needed hundreds of them, so it needed to be policed. And especially with the buffer zone. So Fanning is in charge of that. Now, somehow Fanning got some kind of report. It's not made clear here. We don't know how. Maybe we never will. I don't know. So during the investigation into John's death, he was Proctor's supervisor, meaning there's two lieutenants there that were in charge, and him and Lieutenant Tully. He was one of the recipients of a group text circulated by Proctor that included reference to looking at for nudes. So Fanning did see those inappropriate texts. All right. So after explaining to the attorneys the situation, the court called Juror A to sidebar. And this is the following exchange that occurred. The judge, it's been brought to my attention that you might have been recently out at the American Legion or Knights of Columbia or someplace like that, Columbus or someplace like that in Dedham, and that someone has reported that you may have been recorded talking about this case. That's the information I received. What can you tell me about any of that? So, we heard this stuff about the recording, but I have never been able to confirm or get anything substantial at all about the existence of a recording. So we don't know if a recording actually took place, but it's interesting that the judge put it this way because this puts the juror on the spot. Makes it a little tougher for her to lie because she's thinking to herself, all right, I don't know what they have. I don't know if they have a recording. So she's got to be careful. So what does she say? She says, I don't know. The judge says, have you been at an American Legion hall? And this is where the juror is deceptive. She says, like a month ago. Now, I can confirm that's true. And she did act inappropriate that day, too. Did talk about the case. In any case, we know that she was at the American Legion Hall also the night before that this happened here. So notice her answer. So the question was, have you been at the American Legion Hall? She doesn't say, she doesn't, I think she knows. All right, let me just back up a little bit. Okay, so the judge's first question is, you may have been out recently. That's something like that. So the juror says, I don't know. So there wasn't an accusation that she had been, in the questions here, they don't ask her if she had been out the night before. And so she says like a month ago. And the judge says, okay, at the time you were talking about, and the juror, she's feisty, right? She interrupts the judge and says, not that I remember, no. And the court says, the judge says, do you remember if people there mentioned to you anything about this case? And she says, I was drinking. I don't remember. Plausible deniability, right? Drinking. I'm not drinking alcohol. I should be. I can't remember the last time I had a drink, but I think it was on this show. I think it was when I went on Kate's show. All right. I can relax more because Kate's running it. So it's like If Kate's driving the vehicle, I can have a drink. All right. Let me just check and make sure nobody's in chat. Or nobody's waiting to come in. All right. So she says, I was drinking, I don't remember. And the judge says, okay. The further information I have is that this morning, several Dedham police officers said that they heard the same thing. And she says, okay. And the judge says, all right, well, could it have happened? And she says, I don't know. And the judge says, okay. And the juror says, I really don't know. And I remember that morning, this juror fought like hell to stay on this case, which is surprising because she must have been really hungover, but based on what I know. All right. The court then asked the juror to step aside and then discuss the matter with the attorneys. The state expressed concern that the juror had been involved in the previous issue and requested that the juror be excused. So the state wanted her off the trial because of what had happened in the first issue. This woman was a problem. The defense objected, arguing that the previous incident was unrelated. Focusing on the incident of what happened here, the court conveyed a concern that the juror did not deny that the incident so the juror didn't deny the incident, but instead stated she had been drinking. So that's probably enough alone to pretty much get her thrown off. That's certainly way more than juror B did, right? So the defense responded that the court should consider that no other juror had been affected and that the source of the information was a state police officer. Therefore, a discussion with Lieutenant Fannin ensued. And so we don't know what information Fannin got. We don't know what exactly he passed on to the court and what the court officials, officers, and what they passed on to the judge. We don't know. And the defense right then and there accused the state police of targeting potential jurors for the purpose of trying to get them to exclude from the jury. Now, you got to understand that every defense team is going to have somebody in there watching the jurors. And when they see someone to gauge for different reasons, to see what they react to so they can shape their strategy accordingly. But also if there's a juror that seems to be sympathetic to the defense side, then the defense lawyers are kind of going to focus on her a little bit. They're going to look at her more or him, and because now they have an ally on the jury, and that's what they want. So, but in addition, so they were probably watching her and understood from her facial expressions, ironically, that she didn't like the state or she liked Karen or something like that. But in addition, they already had the incident from earlier in which juror A got juror B thrown off for allegedly saying something about Karen. So you can see why the defense, they knew that she was someone on their side and they didn't want her thrown off. So the court allowed defense counsel to make its argument about why the court should not dismiss the juror. And they brought in Assistant Attorney McLaughlin to explain a little bit more about the role of Fanning. And she says that he's the commander of the extensive security operations. What occurred is he received the information. He did not investigate. He had no evidence of any crime. If he did investigate or reached out to anyone, that could have been considered an improper influence on a jury. So he never did any of that. What he did is reported it to the chief of the trial court security to make the trial court aware as it is simply a trial court issue. So according to the state's version, they just relayed that information to the court. The Commonwealth then made its argument as to why the court should dismiss juror A. They said, I believe there is credible evidence that this juror has had a conversation about this case. She did not deny it. I find that there has been I'm sorry, I'm reading this wrong. So the Commonwealth made their argument, but this here, what I'm reading, is Judge Cannoni's decision that she would have read out loud in that sidebar. So Judge Cannoni says, I believe there is credible evidence that this juror has had conversations about this case. She did not deny it. I find that there has been violation of the court order for failure to report it on a repeated basis. Juror A also had no problem reporting the other juror, but then at the same time also did not tell us that she spoke to the two other jurors that I inquired of. Remember, going back to that, juror A seemingly tried to say that these other two jurors may have heard juror B make this comment about Karen. However, when the judge talked to those other two jurors, what they said was that, well, we didn't hear juror B say this, but we did have juror A tell us that she said this. So juror A told those jurors that, but she didn't tell the judge that she told those jurors that. So there's evidence here again that juror A was misleading the judge. Certainly she held, yeah, I would say misleading is the right word. She told us they may have overheard, and then it was another juror identified by seat number who ultimately told us that this juror had reported to her what the other juror said. So, wow, this juror is sneaky, right? See, to try to back up her case against juror B, she pointed to these other two jurors and said, they may have overheard, figuring they might support the story. Maybe she thought they had an ally. Maybe, I'm going to guess. In fact, I'm going to guess that one of these people that she pointed to as an ally will ultimately turn out to be Victoria, who we're going to meet, who was the alternate juror. And so there's a pretty good chance, I would say, that Victoria and this dismissed juror, whose name I do know, but that they had enough of an interaction behind the scenes that possibly some conversations, but certainly enough that they knew that they both were on the same side and they wanted to acquit Karen. They had already made up that they leaned that way during the trial. So she tried to rope in this other juror thinking that she'd have an ally, but the other juror didn't want to lie to the judge and just said, no, I never heard juror B say that, but juror A did tell me that happened. So juror A's credibility was really shot by this point with the judge. So she says, juror A may not remember whether she spoke about this case, but I wouldn't be surprised if she remained as a juror, if we did hear from somebody who was at the VFW, and it was American Legion, obviously, but she said the VFW that night after all of this. So for all of those reasons, I am going to excuse her from sitting on this jury. And I remember that morning that this juror fought tooth and nail. She fought hard. She was going to defend Karen from hell and high water. And we know that she was going into bars and saying she's a turtle rider and she was going to acquit Karen. She had already done it at least 2 nights by this time. All right. So I'm going to, let's see. All right. So the defendants first, I don't even know if I need to go much more into this. So that was the only thing I really had time to highlight there. The defendant's first argument relies on a significant claim. This is the judge. The defendant's first argument, talking about the Sallyport stuff, relies on a significant claim to clairvoyance. No, I'm sorry. It is about the juror. The defendant's first argument relies on a significant claim to clairvoyance about juror A's sympathies at the time of the sidebar conference, and it is premised on unsubstantiated claims regarding Fanning's involvement with the jury. Again, there's just no evidence. You can try to roll this idea into a conspiracy theory that it's the state police trying to somehow scheme to get this juror off, but it's not the state police that made this juror complain about juror B. It's not the state police that made the juror not tell the judge that she had had a discussion with other jurors about juror B. It's not the state police that made this person go out and get drunk and do a whole bunch of other stuff and say in public places that she was going to acquit Karen and telling people that she's a juror when she swears an oath every day to not talk about the case. Every day they have to swear that oath. So, and like I said, this juror is now in very close contact and has been since the trial with Aiden Kearney. What more do you need to know about this juror, right? All right. Now I want to go to the Vanity Fair article, which I actually didn't even have time to fully read. So I'm going to read it here with you guys. So we'll kind of go through it a little bit. this Vanity Fair writer is just ridiculous. It might as well be the Glare writing it. Like, I don't even understand this kind of journalism. I don't really understand. It's the lowest kind of journalism ever. I can't imagine, and I'm not a trained journalist, right? I cannot imagine that if I was to consider myself a legitimate, respectable, mainstream journalist, and I work for a newspaper or a magazine. I don't care if it's the lower, a magazine that was formed last week and is only online. It seems like the principle of getting involved in a murder case is to try to be objective and get evidence from both sides. What is it so criminal about getting evidence from both sides? This writer made no effort to do that in the glorified article she did with Karen Reed back in this fall, and she doesn't do it here. She just takes what they tell them, and that's it. She makes no question. I mean, it's disturbing. I'm angry about it. I'm angry about that. This kind of juror, this kind of writer, a journalist, is allowed to publish in a major magazine like Vanity Fair. It's disturbing that this goes on. But it's always been a part of the media. They had yellow press problems all the way back in the time of the founding fathers. All right. So this alternate juror, again, who has now been attached to the defense team as a consultant. She's a lawyer. Her name is Victoria Brophy George. She gave a statement to Christina Rex a few weeks ago. She was unhappy with the SJC ruling and the federal judge's ruling on the charges on this case. She's close to Turtle Boy. So is that the connection between the defense and her? Did Turtle Boy arrange her to get this? Did she go to Turtle Boy and say, you know what, I really want to help Karen. Maybe I could be a jury consultant. And Turtle Boy said, yeah, let me reach out to them. I'm pretty good buddies with him. I got him on Signal. I'll dial it up. All right. So when she got the jury summons for the first Karen Reed murder trial, she didn't balk. A Princeton graduate, so she's intelligent, right? Who grew up obsessed with the Supreme Court, who interned with a federal judge. So I'm going to say she's probably also a person of privilege. She can afford to go to Princeton. She's, as far as I know, white, and yet she's interned with a federal judge. She probably has some connections. If you look it up, this sounds like a waspy kind of name. She's probably got some connections. And she got her JD from Northeastern University School of Law. George says she feels a civic obligation to participate in the oft-dreaded enlistment, meaning jury. By the time she turned 34 last year, the employment lawyer had already served on 2 prior juries and acted as a foreperson. So she really wants to be on these juries. Every court has a different process for selecting a foreperson. But for a lawyer to have now served on 3 juries, and she just turned 34 last year, I don't know what's going on. That's weird. Why is she on juries so often? I'm not saying it's suspicious. It's just weird. So she had heard about Karen Reed. The Massachusetts woman was all over Boston media. And let's see. She says that at the time, I was able to be a juror because I believed that the state court system was going to give her a fair trial. All right, so this is important too. People said, we talked about the gag order. So she told Vanity Fair weeks before she joined the team. So why didn't Vanity Fair publish it till now? Vanity Fair publishes this the day that it's announced that this person joined the team. So clearly she knew. This is interesting, right? This is interesting. Stop the presses because this is interesting. Think this through. So it was only a few weeks ago that she gave this statement to Christina Rex to be published by Christina, complaining about the justice system here. All right. And at the time, she just represented herself as a juror. But this sounds like she must have already known at that time that she was joining Karen's team, because she told Vanity Fair this story weeks before she joined the team. And it's coming out now, the day that Yannetti and the defense team announced she was joining it. That is not a coincidence. That is a plan. That is a strategy. All right. So I would bet anything that that's what happened here. All right. So this writer for Vanity Fair might as well put her on the defense team too, because she pretty much is. Right. So the juror conspired with her and said, I'm telling you my story now so you can get ready, but don't put this out. Don't publish this until it becomes public that I'm on the team. But I don't want to join the team officially yet, because first I want to give Christina Rex this story about how corrupt the justice system is in the Karen Reed case. That might even need to be investigated. If she had an agreement, even she wasn't on the team, but she had a verbal agreement that she was joining the Karen Reed team. She had that agreement, and after making that agreement, she's releasing statements like that to Christina Rex. Something feels criminal about that, and I'm not a lawyer, but that feels like it's a violation of something. So maybe some of our team lawyers can look into that and think that through for us. But something, did Karen's defense team, were they part of this strategy? Did they know? Did they conceive of this plan? It's just one more shady thing. One super shady thing. All right. So Victoria George is a conscientious rule follower. Once during the trial, after she drove past the Free Karen Reed billboard outside Gillette Stadium, she told Norfolk County Superior Court Judge Beverly Cannoni to make sure she was on the up and up. And the court assured her she was. God, that's like Arnold Horshack from Welcome Back Corner. Oh. Sorry, no one here probably remembers that show. But Judge, I passed by a sign. I just wanted in the morning, every morning when they say, you have to tell her, have you raise your hand and swear that you have not seen anything in the media about this. You have not discussed this case with anybody. Obviously, Juror A was very likely lying about that. But this juror tells the judge about a billboard. Come on. That's crazy. And that's also, she doth protest too much, which means she's got some other plan in her mind already, and she's trying to clear that. She's trying to establish an evidence trail, just how much she's a rule stickler. She even talked about the billboard with the judge. I really wish that the judge, I'm telling you, I would bet that one of those two jurors that Juror A was talking to was Victoria George. Guarantee it. I don't want to guarantee it. Let's make that bet though. Wouldn't bet my life, but I would. I was gonna make a bad joke. I wouldn't bet my life, but I would bet my life savings on it. Oh, you need something more substantial than that? I would bet my hair. No, that's not gonna work either. All right. During the 9 weeks of trial, she says that she and the other jurors stretched conversation limits to avoid talk of the case, which could not begin until deliberations. So once during deliberations, then they can talk about the case. When another fellow juror began to openly criticize, so they go into this. All right. So when another juror began to openly criticize Karen before deliberations began, according to several jurors, she and her peers reported the person to Cannoni. This does not match the story that we're told by Judge Cannoni at all. Judge Cannoni's, we just read it out loud. So something is missing here, right? Judge Cannoni says it was only Juror A that said this. But this article, which is only using this shady pro Karen Reed juror as a source, says, all right, this says, according to several jurors, all these jurors are talking to Vanity Fair. What is going on? She and her peers reported the person to Canoni. The juror they reported was dismissed. Again, this is just not what this is not what the judge reported. And the judge is not going to lie. So it does sound like this juror was in that group, and now they're giving dishonest information to Vanity Fair, or Vanity Fair is misreporting this. I'm going to bet that the only juror that Vanity Fair spoke with was this Victoria, and she's the one that probably said, according to several jurors. So when the reporter says here, when this article says, according to several jurors, I don't think this reporter talked to several jurors. She talked to one. And that one juror said, according to several jurors, she and her peers reported the person to Canoni. It's just not what Canoni said. So this Victoria, I'm sorry, one person is lying. Either Judge Canoni or Victoria George. I'm going to go with this Victoria George, the person who is in regular communication with Turtle Boy, the person who is arranging this friendly article in a deceptive way, so that it won't be published until she's announced that she's on the team. It's all shady doings. And Judge Canoni's not doing any shady doings, so I'm gonna guess that Canoni's telling the truth, and this juror is not. For George, the fulcrum trial moment was when State Police Trooper Proctor, all right, we know all this. She says, knowing he was the lead investigator and based on his own words, he had a pretty strong personal bias against the person in the defendant's chair. How do you ever trust the evidence coming from this investigation? Okay, it's a shallow way of looking at it, and I would expect somebody who went to Princeton to have a better way of looking at it. Because I have no problem, and as I've said before, if you want to take all of the evidence that was collected by Michael Proctor, and there's no reason to doubt any of that evidence, but if you want to say just erring on the side of safety because he had a bias demonstrated in his text, let's get rid of all that evidence. And they did a lot of this in the OJ trial. There was a lot of powerful blood evidence against OJ that the prosecution decided not to use because they were afraid. They just had the Rodney King riots, and Mark Furman had possibly made some racist comments. So they were afraid that the juror would dismiss any evidence that was collected by the Los Angeles police. So a lot of really good evidence by the Los Angeles police was not used by the prosecution for that reason. So it's not an unreasonable thing to tell the jury, all right, fine, drop all this evidence. There's no real reason to. So I'm not saying the state should do that. But if you're a juror, you can sit there and say, all right, what evidence did Michael Proctor actually gather? All right. What is the key evidence here? The key evidence is the taillight pieces that were found in a debris pattern. All right. Michael Proctor was not there on the day of John's death, so he did not find those initial pieces and the most important pieces for that. And that main piece, which links to Karen's car, was found by the CERT team at 5:45 with no Proctor there. So if you want to eliminate the Proctor any evidence that Proctor handled, that's not it. Okay, that one is still in. And that Proctor didn't find that evidence. So the most compelling, Proctor didn't make Karen Reed say, I hit him. Proctor didn't tell those witnesses, multiple witnesses, he didn't instruct them to testify that they heard that. Proctor had nothing to do with the vehicle data. The vehicle data was compiled by Trooper Paul. And that shows Karen backing up for, 60, 70 feet at 24 miles an hour. Sorry, I was just reading the text. And I did get a reply from Claire Marie, so I will go back to that. Thank you, Claire Marie. I didn't have time to read it yet, but I did see that I got one from you. Proctor had nothing to do with that vehicle data that shows Karen going backwards at that crazy speed in reverse for a long distance. Proctor will have nothing to do with the evidence that we're going to see in this trial. That I guess has timestamps and GPS based on what Brennan said in court last week about time and place. Proctor had nothing to do with John's phone data that was collected by and put together by Trooper Garino, and that shows that John never went in the house. So you can get rid of all the evidence you want that you think Proctor somehow, had some corrupt influence over, but that doesn't even touch any of the fundamental evidence against Karen. So this juror didn't notice that, I guess. To me, that suggests that, and many other things here suggest the bias is on her part. Okay, she's looking for a reason to dismiss the state's case here for some reason. Her own ideology, a woman thing. I don't know. I don't know what it is. Maybe she's an ideologue and she believes the system is rigged against women and it was men in the house that did it, but now they're blaming an innocent. You don't know why someone has a bias. On the day of closing arguments, a juror who appeared sympathetic to the defense was dismissed. We just talked about her. As revealed in court earlier this month, the dismissal was prompted by Mass State Police Officer John Fanning, one of Proctor's supervisors, who Reed's lawyer, Alan Jackson, says had been on the whack job text chain. So, they make no effort. They just run with the defense theory 100% in Vanity Fair. If Karen Reed tells it to them, they run with it. That's it. It's ridiculous. No sense of skepticism. It doesn't occur to this writer that a defendant on trial for murder might not always be telling the truth, would have an incentive to lie. It's crazy. All right. One of Proctor's supervisors, again, while huddled at sidebar to discuss the reason for the juror's dismissal, Reed's lawyers learned that Fanning, an investigator on the case working out of Morrissey's office, had that morning reported an alleged incident that he had not personally witnessed. Okay, but that was not the basis for her dismissal. The judge was told a report that ultimately was relayed by Fanning. Now, let's just say allegedly Fanning made this up because he wanted to get rid of that juror. But the judge didn't take his word. The judge asked the juror, was it true? And she said, I don't know. So to think that Fanning made this up is ridiculous. The juror was evasive with her replies. Now, Vanity Fair maybe didn't have access to that because it was published. Oh, they could have. Because it looks like this was published today, and the denial of the motion to dismiss, that document that I've been reading from tonight came out yesterday. But did they make any other effort to, they were just taking the defense's version of this. It's irresponsible. All right. So this is as far as I read before the show began. So let me just I'll have to read through the whole article quickly. Let me check and make sure nobody showed up. All right. So there was no evidence presented at the time, as the court knows. Jackson told Cannoni during a fired exchange in the motion to dismiss argument. There was no declaration. There was no report. There was no supporting documentation whatsoever over the defense's objection. This very potentially defense-friendly juror was then excused. All right. She's reading from their motion to dismiss, but the judge didn't dismiss this juror based on evidence that was presented. She dismissed it based on her voir dire of this juror. So again, it's just more false media stuff that's put out by this very clever and sneaky defense team. So over the defense's objection, this very potentially defense-friendly corrupt juror, was then excused. I asked the court to take evidence from Lieutenant Fanning. The court declined that invitation. So the defense, they're saying here that they asked the Lieutenant Fanning to get that evidence, but the judge decided it wasn't necessary because the juror gave her an evasive answer, and because there was a problem with the jurors when she complained about juror B, where she didn't completely tell the truth. Cannoni did not dispute Jackson's recollection of those events, but asserted that Fanning did not have direct or indirect access to the jury. In the state of Massachusetts, so they're basing this on the hearing. In the state of Massachusetts, alternate jurors are selected at the end of the trial. Several hours after the aforementioned juror's dismissal, the court magistrate rotated a box on a spindle and pulled out 2 tiles. He did not show the numbers to the court, but said they belonged to George and the other juror who had reported the critical juror of the judge. So they're implying that the process was rigged. George requested a sidebar with Cannoni, and she recalls saying that their dismissal from the voting pool did not seem like a coincidence. Judge Cannoni declined to comment from the story, as though a judge in a trial is going to comment. Jesus, they just put that in to make it look suspicious. But so it sounds like Victoria took her problem to the judge. Remember, this was probably the next day when she was crying and wearing pink. All indications that it's Victoria George that should never have been on the jury in the first place. George had hoped her legal skills could be helpful in the deliberation room, so she's going to try to steer jurors. She's the perfect turtle plant, perfect free Karen Reed plant, as they had during a previous trial, during which she served as a 4-person. So, man, I hate to wonder what that other trial was, because this juror does not sound like someone that should be on a jury, and definitely should not be a 4-person. Not, for all the reasons I said. In the state of Massachusetts, the judge chooses the 4-person based on a number of factors such as attentiveness through trial and demeanor. Other times, the decision can be made arbitrarily based on seat number. The times I've been on a jury, it does seem like it was made by seat number. The last time I was on a trial, the foreman was on an end seat, so I think it was by that. But the one that you do get to know each other during a trial. He was the quietest guy. No one knew this guy until he was selected. And then when he was selected, he turns out he was a very smart engineer with a master's in engineering that worked for Boston Dynamics, the robot making company. And he did a good job. All right. So to preside over the fate of Karen, a woman being charged with fatally hitting her police boyfriend, Cannoni selected a retired Boston police officer to act as a 4-person. I thought Turtle Boy said he was like a doctor or something or a medical assistant or something like that. A retired Boston police officer. And there's no. It's just so disturbing that the foreman left such intelligent notes. I would say they got a good person. During the trial, according to 2 jurors, the cop told his peers that he'd been hit by a car. Where is the proof of this? Where is the proof of this? That this juror, I've never heard that he's a retired Boston police officer. I've never heard that. Where are they getting this information? Do they have some way to verify it? Do they just get their shit from Tom CPU? I mean, where does Vanity Fair get this stuff? They just take anything that they can use to run with these narratives. It's unbelievable. So, according to 2 jurors, the cop told his peers that they're just talking to free Karen Reed people. According to multiple jurors who have come forward since a mistrial was declared, there was confusion in the deliberation room about whether or not jurors could declare a partial verdict. Even though that's now in front of the circuit court. Even though the jurors were unanimous in deciding Karen was not guilty of second-degree murder and leaving the scene, they were split on the manslaughter charge. Yet the letter from the foreman that Cannoni read aloud in the courtroom indicated that they were deadlocked on the charges, plural, and a mistrial was declared. Well, nobody complained at the time of these jurors, so they had a chance to meet with. The judge goes in and meets with them right after the mistrial was declared. Doesn't sound like anybody complained at the time. They only complained later as these free Karen Reed jurors got together with Turtle Boy. All right. Karen has appealed the verdict. All right. So Victoria George has 4 children under 5, including infant twin sons and had no desire to come forward. Yeah, bullshit. Bullshit. Give me a break. No desire to come forward. She's been inserting herself into this case. Look, she's been on 3 juries and she's been a foreman on 1. She wanted to be the foreman of this jury. That's why she was crying the next day when she was excluded. Give me a break. I have no desire to come forward, but yet I'm reaching out to Turtle Boy. Give me a break. I waited for nearly a year after the mistrial, she says, hoping the court system would work as intended to remedy some of the wrongs in the case. The wrongs based on her Free Karen Reed analysis. During the March 5th pretrial hearing, Jackson argued that Karen's case should be dismissed for reasons of extraordinary government misconduct, including Proctor's bias, investigative failings, and the suspicion of jury impropriety. And the fact that some of the video evidence was withheld. On Tuesday, Canoni rejected Reed's request. So they did have this motion. Did they read it? Which the Commonwealth has called an oversight and denied Reed's motion to dismiss because the claimed violations here do not rise to a level that would justify the most draconian sanctions of dismissal. So they read, it's just getting more and more frustrating. So they read the decision that I just read to you here, but they still, even though their article is about the juror, they seem to have not read any of that, or they ignored it. But it was how Hank Brennan, the special prosecutor, responded to Jackson's allegation of jury tampering that compelled George to speak up. Brennan, who previously defended Whitey Bulger in federal court, suggested that Reed's claims of extraordinary government misconduct were dangerous and reckless, with the potential to cause the public to question the fabric of our entire judicial system. He's right. There's no question he's right on that. The claims that they made of extraordinary government misconduct don't exist here. There's no evidence for any of it. No evidence that anything was intentionally withheld. There's no evidence that anything was held that was material for a defense. There's no evidence that the lottery to determine who was dismissed, who became the alternate, was somehow rigged. No evidence for it. There's no evidence for any of this shit. Victoria tells Vanity Fair, Attorney Brennan implied that the defense was responsible for causing sentiments of distrust in the justice system simply by questioning inconsistency, inconvenient facts, and missing evidence. Look, honey, if you actually look at this evidence, all the defense has done is make distortions, and that is what's prejudicing the public. All right? This whole conspiracy theory has been whipped up by a bunch of nonsense. It's fooled the public, and maybe it's fooled you because you have a pink dress in your closet. But Brennan is exactly right. As I've gone over on this case many times, the defense is constantly distorting everything. I've already mentioned the gap in the Sally Port, the gap in the library video. There was no gap. It's motion triggered. And on the defense does this, whether it's a non-human hair, whether it's trying to suggest that Proctor had John's clothes in the back of his car for 6 weeks. That's perfectly explained too. They were not in the back of his car. They were turned in a properly sealed evidence bag into the evidence room at the district attorney's office. It's called the evidence room. And 2 troopers are assigned as evidence officers. They have access to it. Trooper Proctor was not one. Trooper Buchanan was not one. It's called the evidence room. But it's 6 weeks later, it's transferred to a state police lab for testing. That's when it goes into the state police system, their computer system. That's when it's logged in. Alan Jackson knows that. David Yannetti knows that. But they try to put it out there. They put it out there in the documentary, and they put it out during the trial. Ooh, that evidence, where was it? Where was it for those 6 weeks? They know where it was, but they want to fool the public. So yes, Attorney Brennan is 100% right that it's the defense that is creating this distrust in the justice system by constantly distorting things. Constantly. To me, it's so unethical. It's unbelievable. But I blame a lot of us in the public for following it. But this person, George, I mean, she's not a criminal justice lawyer, so maybe she doesn't understand a lot of these things. I don't know. But she should have enough common sense, even though she does civil law, of understanding that this is a defense team's job. If you just give me a call, Victoria George, if you want the truth, and I'll at least get you started. All right. I'll explain how many things. In 15 minutes or half hour, I'll explain to you all the things that the defense has put out that are indisputably false. I won't lie to you. I'm not going to tell you things I don't know. I don't know what caused the butt dials. I don't know. Right? I'm not going to tell you that. I'm not going to tell you those things because I don't know them. But I will tell you things that the defense has said, many things over the last 2 years that were proved to be indisputably false. And then will you develop some skepticism about what a defense team is? If you care about the truth and you care about justice and you want the system to be trusted, yes, exposing any corruption or wrongdoing or bias, improper behavior, yes, that's all important too. But there's a lot of other things going on here. She says, at that point, she decided if, as a lawyer, I was too afraid to stand up for what I believed in, who would? So is this a cause? Did this become your identity? So this is a cause for you. And you decided this when? At the end of the trial? Before the trial? It sounds like you have a previous history of this. So you don't sound like an impartial juror to me. You sound like you're someone who came on to this jury with an axe to grind for whatever reason. You had a pink dress and you wore it in court after you were made an alternate. There's a lot of disturbing problems here. All right. Even after the circumstances of her dismissal from the deliberating jury pool and the contested mistrial verdict, George had been hopeful when Brennan was assigned to the case. The respected Boston lawyer released a statement last fall saying that one of his core obligations was to make certain that Karen Reed receives a fair trial and the dignity and fairness that every defendant deserves in our criminal justice system. Says George, I was impressed by his background and naively thought that he would see the overwhelming evidentiary issues with the case against Karen Reed. You're the one that's naive, Victoria George. You're the one that isn't smart enough to see through the evidence, and I'm sorry you're not. You're the one that was so biased while you were watching this case that you couldn't figure out that most of the stuff that the defense was saying was easily debunked during this case. You couldn't figure it out. I'm sorry you couldn't figure it out. I'm sorry to be mean. The problem is not Brennan. The problem was you. All right. At minimum, I thought he would encourage the Norfolk District Attorney's Office to dismiss 2 of the charges, given constitutional double jeopardy concerns. I mean, I think the obvious thing that went on here in that jury room is you take the temperature of the room when you first start deliberating on the various charges. You're trying to feel your way through. And it sounds like 2 of the charges, the jurors, at least on this first vote, said no. But that's not a formal vote, and it shouldn't be equated as one. And because it was common sense that you have to first establish that Karen's Lexus did hit John O'Keefe first. That was the second charge that comes under the manslaughter charge. And only once you get unanimous decision on that, then you can go back and decide whether she left the scene of the accident. So if Karen did strike John with the Lexus, and if you get unanimous decision on that, that still doesn't mean automatically that she's guilty of leaving the scene of the accident, because she would have to know that there was an accident and you would have to prove that. And it might be hard to prove that. And likewise with second-degree murder, you'd have to prove some level of malicious intent, which could be as simple as not calling 911. But there's no point of getting into the weeds on those things until you first agree that the Lexus struck John. And they never quite got to that level. The jurors were split on that. So George was bothered by another seeming constitutional right at risk in Karen's case, her entitlement to the defense of her choosing. Oh my God. How did this person become a lawyer? How did she get on the jury? What is going on with this state? What is in the water of this state? She thinks that Karen Reed is entitled to Mark Betterow, who is Turtle Boy's defense lawyer. That's clearly a conflict of interest. Even someone who took a course in law, one course, could understand that. My God, what is wrong with this person? Why? And she brings this up here. She's just looking for. She's a turtle rider. All right. Earlier this month, Canoni denied Karen's request to add Mark Betterow, a former Manhattan assistant district attorney, to her team. Because Betterow represents Aiden Kearney, the blogger known as Turtle Boy, Canoni determined that Karen retaining him would constitute a conflict of interest that is not waivable. Absolutely. Especially now, right? Looking at the motion to get communications to get Turtle Boy's phones relevant by Hank Brennan relevant to this case. They don't need Betterow. What do they need Betterow for? They have an all-star team, and he's not an all-star. So George called Jackson shortly after seeing the ruling. Again, when I'm saying George, this is Victoria George. It's a woman. Called Jackson shortly after seeing the ruling to express her mounting frustration as Reed's second murder trial approached. Which ruling? Color me skeptical. She's obviously this was obviously not her first communication with Alan Jackson. And there's no reason for her to be in communication. Some of the jurors had some reason to, because they were the ones that were claiming that there was a unanimous decision on charges 1 and 3. But George was not part of those. Victoria George was not part of those decisions because she wasn't in the deliberation. So when did which ruling made her reach out? Was it the ruling that we just got yesterday, the denial of the motion to dismiss? Or, oh no, it sounds like it's the motion to not allow Betterow. But again, that was only a couple weeks ago, and she did this interview a few weeks ago. So I don't know. George joked that she is still licensed to practice law in Massachusetts should Reed need an extra hand. Over the course of the conversation, the suggestion became less of a joke. What conversation did she need to have? Why would Jackson even take her call? Unless it was to be a consultant based on her being a juror, because she was not part of the deliberation. Over the course of the conversation, the suggestion became less of a joke and more of a potential reality. On March 26th, Karen filed a motion to add George to the team. The case has garnered so much media attention and so many polarized reactions that George hopes the public and future jurors can remember that two things can be true at once. So she wants to influence future jurors. This is a lawyer, an alleged lawyer, who is trying to present herself as some kind of an objective juror. But here she says she wants to influence future jurors with these statements. She says, what happened to... Now, if she was going to say something general that was not about this case, that she wants, like if she was going to say, I hope that all future jurors will keep in mind that the state has an obligation to prove its case beyond a reasonable doubt. I know that's generic, whatever. She doesn't say that. She wants jurors to know. She wants future jurors to know that what happened to John O'Keefe was a tragedy, but just because something is sad doesn't mean that the person in the defendant's seat is responsible. I can feel bad for his family and believe she's not guilty at the same time. I don't believe you feel bad for his family. There's just too much evidence here. But you're trying to tell future jurors, you're trying to contaminate the jury pool. So thus my thumbnail here, pink contamination of the jury pool. That's the end of this utterly absurd article. Oh, I apologize. I was reading from an article without switching over to that article, so you could not read it with me. So I apologize. And we could go over to the rest of the motions to dismiss, but I'm not going to, because I'm starting to get tired and I want to get to the point where we take on questions. So We also are learning today that there seems to be a request to get a emergency hearing, preferably this week, regarding the thumbnail with communications between Turtle Boy and Karen, or Turtle Boy and Karen's lawyers, or something like that. So, even though at the moment there is no meeting scheduled, there is no hearing scheduled, there may be an emergency hearing tomorrow or Friday. And this is all urgent because the trial starts Tuesday. So, I don't have any details, you know, beyond what we know vaguely on that. So, um, they've been ordered to appear as soon as practicable in the Norfolk Superior Court for a hearing related to the content of Turtle Boy's phones that have been turned over to Hank, and also to Karen's defense. This will probably mean a hearing this week, I would say. Um, I don't know. I guess in theory it could be Monday, but you're running out of time on all this stuff. So, I'm actually not even sure what the hearing's about, because the thumbnail, my understanding, was already ordered. The information was already ordered. It was already approved by the court last week. And so Cosgrove should have already turned it over. But you know, we'd have to get a lawyer on to parse some of this stuff, or maybe Kate, and don't have access to either at the moment. And my back is starting to kill me. So just quickly before I get to questions and thank yous, um, for anybody that wants to order the book, which comes out April 1st, you can order the paperback or the hardcover now, and putting the link in below. You can also find it on Amazon, Storm of Suspicion, the murder trials of Karen Reed, something like that. But if you put it under Amazon Books, Storm of Suspicion, it'll come up right away at number one. So again, for people that do that, thank you for the support. The idea is to get the publisher to get their money back on this, that they invested in this. There's, several $1,000s go invested into it, because they're taking a chance on something like this. So we have to appreciate that. This is not generally an exciting kind of case that did have a lot of sex appeal, you would think, for the public. As like, say, a serial killer or something like that. So Heather, our resident lawyer, said the hearing is likely pursuant to the motion granted in part, and is just what Cosgrove is likely turning over under that. Okay. Thank you, Heather. Thank you, Heather. Appreciate it, as always. And the dude abides is here, man. Do you see the sign? And I'm gonna, I'll see how this looks after. It's the dude is here, and he ordered this sign for me. For us, really. We all get to kind of look. You guys get to look at it more than me. I can't really see it, but apparently the solution was to put more light in the room. And but I also got this stuff that came in today, these gel filters. So I'm going to dim it even more with that. So thank you very much to dude. Appreciate it. And his always has these clever comments. And today he says, fate whispers to the man, you cannot withstand this storm. The man whispers back, I am the storm. Hank Brennan. So we're hoping that's true. All right. So thank you, Frank Perry. It was nice that Hank asked the question I have asked. How did they know Karen was not going to come in the house? Where were they ready to kill her too? Yes, Hank did a great job. I got to stretch for a second. All right. So Hank did bring that up, and it's a great point. Why? Oh, I want to get to the why. So if the plan is to lure John in to be attacked, how could they know that Karen wasn't going to come in? That's Hank brought that up, and Frank likes that point too. So thank you. And the real anonymous lawyer, listening to the article, emailed me. Totally agree with your exasperation with that article. I'm pretty sure Julie Miller, the Hollywood Report, has a long-time source relationship with Alan Jackson, dating at least back to all of her writing on the Kevin Spacey case. She seems to be willing to print whatever Jackson feeds her. That whole article seems to me like a pretty brazen violation of the gag order. See, if you noticed, Anonymous, they seem to cleverly get around it by saying that she only joined the team today, but they said straight up in there that the juror talked that Victoria spoke to them 3 weeks ago. So they tried to get around it that way. So they were clearly aware of this. And so he says clearly Jackson was behind it. And Victoria George is on the record throughout, despite clearly knowing she was joining the defense team. That article was clearly coordinated and embargoed until today. Exactly. So I like it when smarter people conclude the same as me. So thank you. If I was Judge Canone, this article would really piss me off. Just totally non-subtle defiance of her gag order. So let's get to all right. So if you remember, Claire asked in an email to me earlier, and this is again, I've made my email available to people, and Claire is not only a great contributor in chat, but also has been a big financial supporter of the channel. But people email me during the show, and I try to get those emails during the show, especially if it's from someone that is a regular, a source, or just a good person. So, the people that thought I was ignoring them the other day, they could have emailed me, and I would have seen it. And ironically, I probably didn't see their question because someone named Frank, who I had never spoken to before, emailed me, and he said he had sent a message to. I think he sent it to. Yeah, he sent it to Lally, to the DA's office, and I read his message out on the channel. So, but while I was reading it, like I am now, going to read a little bit from Claire Marie's, I couldn't see the chat. So I'm damned if I do. If I go to respond to these things on email, that I miss the questions. All right. So, but I think we're doing it the right way. Just people have to be patient and say, I'm going to eventually get to all the questions and do the best I can to get to them. So, but during the middle of the show, if you ask questions, I may see them, I may not. All right. So the question, the idea that Claire Marie had was, where did the ARCA guys even get the idea that John threw his cocktail glass? And she said that it sounded like there was some statements where Karen had said something similar, but I don't remember where they was from. So we'll see and I asked her if she could let us know, and we'll see if that's in the answer here. Oh, all right. So she doesn't really tell us. All right. So again, Claire Marie, you mentioned in your first email that Karen herself had said something, and I don't remember where. Please tell me if you can find where that was and get back to me on that, because I do think it's really interesting if she did say that. I just don't remember her saying that, but obviously she's done a lot of interviews. I might have missed it. Maybe it's in the Vanity. So try and find that and let me know, Claire Murray. Thank you. Jen said, email me to say thank you. You're welcome, Jen. And oh, I'm gonna be careful. I gotta be careful not to. Somebody said my joke had him in tears. That's hard for me to do. So So, and then someone else had messaged to say perhaps Victoria should look at the Adelson case and see what happened to Roshbaum. I don't follow that case. I've heard of it, but when he tried to represent both Donna and Charlie. So I don't know who these people are, but she says it didn't end well. So there was precedent here for that kind of conflict of interest that the judge didn't allow to happen here. And I don't really, I'm just baffled that this alleged lawyer, um, Victoria George, didn't understand there's a conflict of interest. She's just spewing the latest Turtle Boy points. So it's disturbing. All right. So Jack D with his $6.62 donation. I wonder if is there a specific meaning behind that, Jack? But thank you very much. And he said no message. I like that too, because he could have just left no message, but he said no message. Thank you, Jack. Lisa Cox said, thank you for all your hard work, Kevin. You're welcome, Lisa, and good to have you here as always. You know that. And James Clay, another great old regular from us, said, buy a few books on me and the labor attorney, Kevin. Justice for JJ. Thank you, James. Fallback Girl. We just saw her for the first time on the other show that I remember, and she had some good comments. So I appreciate your logical reviews. I am very worried about getting justice for Officer O'Keefe and his family. If I remember, Fallback Girl, wasn't she not from New England too? If I remember, I forget. I think I don't know. I'm trying to remember if she said where she was. All right. The Dude Abides. Oh, I already got the Dude Abides. Great comment. Thank you, dude. Andy Dufresne, any update on your treatment plan? I'll find out tomorrow at 4. Find out tomorrow at 4. That's my appointment. And JM373, postpone the trial till September. Get the motions, voir dires, appeals, etc. done by the end of May. Let the pink people do something else for a couple of months. But come on, they have to have something to do, right? What are they going to do? I don't want to see it postponed. I don't think it's fair to the O'Keefe family. I don't think it's fair to the witnesses. I mean, if it has to be, it has to be. But I don't think it does have to be at this point. So, for a selfish reason, I just want to move on from this case forever. I wanted to a year ago. So, all right. Now is that time to ask questions. And so it is an idea to put in the question marks, and I will, that's good, but I'm going to try to see everything. So I will do the best that I can to answer questions, and I will stay on pretty much as long as needed to answer those questions or just make your points. I guess we'll still have to talk about the questions from the other day. It was just what triggered me was seeing someone going on and on and on, and it's not the first time that it happened with that person. And they were saying I was being accused of ignoring comments, and I can understand the frustration that I don't see the comments, but why would someone accuse me of ignoring comments? That's what bothered me. But I consider us all family, so I'll give them my number if they want to call me. Um, family has arguments, so that's life. But let's try to talk about the case. Sarah says the neon sign looks great. And this is the dude Abide. So you see commenting right above you. He's the one that ordered that sign and surprised me with it. I didn't know until I opened it. So that's the dude. And there's a way to put it on a flickering mode too, but I don't know if it'll work. Yeah, I don't know that whole theory about how Karen now suddenly saying that she took a glass from the waterfall, but we see in the video that John took the glass in the waterfall. So maybe she didn't know that at the time that she recorded that statement. I don't know. So Z in the house says, based on the new detailed third party motion, do you think Hank should push the feds for any additional exculpatory evidence of those three witnesses? I hope he is. I hope he is. He has no power to compel, neither does the judge. Only the feds' sense of conscience has the power to compel them. But one other thing, the only thing the U.S. Attorney's Office tends to respond to, the thing they care most about, is headlines. Bad headlines and good headlines. And that's the pressure that I've been kind of hell bent on that since the end of the first trial and before, is to make headlines that'll make them respond. I'm not big enough to do it, but I hope that as I report things which are truthful and documented, that somebody bigger would pick them up and investigate that. Somebody in regular media, because that will really create pressure on them. I believe they do have exculpatory evidence in the form of data, perhaps other things, on the witnesses. They're not required to get it open because the witnesses aren't defendants. Yes, I got it. Wouldn't the geofence data show that John didn't go in the house? Yes, it would. But that's not exculpatory to Karen. So they're not required to turn that over if they have it. We don't know what they have because they don't say what evidence that the feds got. But it would have been routine and easy for them to get geofence from the house. So I can't imagine that they didn't. You know? I don't, man, there was a bunch of rulings today. I don't think I saw anything on third party yet. So there was a ruling on the buffer zone. It was expanded. There's also a ruling. Oops, got the wrong one. On Karen will be allowed to wear headset when the team goes into sidebar. Proctor could have pulled that geofence data. I don't know what the time is. It's not like you can wait 5 years. Proctor had no reason to, because he knew that John didn't go in the house, and he didn't know in that first year that this was going to be the defense's strategy. So he wouldn't have thought of it. But the feds, I believe, did think of it because they were subpoenaing the communications of the people inside the house less than a year after John's death. They did that in December of 2022. Can George be denied to join the defense team? I don't know, because this is different than Betterow. I don't. Heather, you can let us know. There must be a difference between someone who joins the defense team and is going to sit at the table with the defendant and be eligible to address the court. And whereas I think what this Victoria has been hired to do is really just be a consultant in the background. So I'm not sure if you need permission for that. I mean, in theory, they could have Nick on as a consultant, right? He's not a lawyer, but I gotta stretch. Sorry. I can still see the chat. Oh, see, I was just reading a comment and I couldn't finish it because the chat moved too fast. That's the nature of the beast. It was a long comment. It seemed good, but the chat moved, so I didn't get to the end of it. That's what happens when you get a bunch on. So we've got 535 people right now. Oh, and see the question mark. So you look away for a second and you miss something. D says, Kevin, I was going to ask a question, but I would feel much better if you signed off because the most important thing. But go ahead, ask the question. I'm a trooper. I can hang in there. I don't always have the answers. I'm just a dude on with a mic, you know. But I can ask people stuff. And sometimes you ask a question and there's somebody that does have expertise, like the anonymous masked lawyer or Heather, that can email me an answer, and I might even get it before the show's over. So, Chick from the Brick says, "Can George be den?" Oh, I already answered that. All right. Not saying you should, but I can scroll back. Can't Kevin? I can scroll back, but then when I start doing that, I get lost, and now I can't. Now I miss more comments. So it's I do sometimes, like if I see a problem, I will scroll back to try to identify the problem. But otherwise, you know, so it is, if chat's rolling fast like this, it's best to get me a relatively short question that's easy to read. If it's like 5 lines wrong, it might move up too fast at my slow reading comprehension. Yeah, so Joe knows because she's moderating. It's not that easy to roll back and chat while it's moving. I don't know. It is what it is. It's not the easiest format to do things, but see, Paul Carroll's got a good comment, but it's kind of probably too long for me to read. It moves slow. See, I try to clear it. All right, I got it. Paul Carroll says, honestly, I don't think the attorney ethics rule about conflicts was even written with a situation like this in mind. Who on the ethics board could have predicted this? Well, conflict, but there's other types of conflicts of interest that have happened, I'm sure, many times. Jen says, how long will the trial last? Attorney Brennan said they're 3.5 to 4 weeks for them, and the defense said 1 to 1.5 weeks for them. So then you got potential rebuttal witnesses that didn't happen last time, but as a potential, and you have the jury deliberations and things like that. Maybe on a different computer. It's just the nature of the beast. There's over 500 people here, so chat's moving. You know. You're welcome, JF Stu. Pat, notice the man with the axe behind me. Yeah, don't worry about it. That's just a ghost. Samantha, Kevin, wish you good with your health. You seem like a good dude, especially with your pursuit of the truth. For John, thank you for being the voice of reason. So you're welcome, Sam. And I never have claimed to be an expert. I just do the best I can. I talk to people that have more knowledge. You try to get to the truth. Sometimes it just takes your own investigation. Like even the answer to why the Lexus was towed to the Sally Port only partly came out in trial, but it was enough that you can kind of start figuring out, well, all right. It actually would for all right. So for me, what unlocked one of the real reason I believe that the Lexus was towed to the Sally Port. One of the reasons that they list was perfectly valid. The troopers said that it was because the Sally Port was heated. That makes sense because you had ice and snow on the car. You can't scrape it off. It's evidence. So, but when as I just talked about earlier, the mystery of Michael Block, with John O'Keefe's clothing. Why did it take 6 weeks for that clothing to enter the state police computer system? And we now know the reason why is because it was stored initially at the evidence room, where at the district attorney's office. And then when you start thinking it through, so before this case, I didn't understand that a state police homicide investigation is actually run by detectives that are assigned to the county district court. The county district attorney. That's how it is all across the state. So Trooper Proctor and Trooper Buchanan are detectives that they didn't go to work every day at a police barracks. They went to work every day at the district attorney's office. And so the light's going off in my head. Yeah, that makes sense. So the evidence is taken to the evidence room at the district attorney's office. And the murder weapon, which is a vehicle, is towed to the facility that is closest to the prosecution. So it's just kind of a normal instinct. Everything is initially during the investigation being taken closest to the prosecution. The investigation is being run out of the district attorney's office. So you want to get all that evidence as close as possible to there. Now, eventually it might get moved someplace else for storage or a state police lab or something like that. But that's just kind of a default. So they wouldn't have thought twice about it. And in these investigations, the state police are partners with local police. So it always exactly if this accident or homicide or whatever you want to call it took place in the summer, they still would have towed that Lexus to the Sally Port. It was always the most logical place. Good night, Karen. The Pilgrim Shadow, thank you, says you're a man of integrity. I pray for your physical well-being. Faith moves mountains. Well, science moves mountains too. And I appreciate the prayers for faith. I will take the help from any department I'll get. But science has kept me here this far. Comfort and Joy, one of our old regulars. TB said last night that Karen should never have conceded that what he was doing was harassment. But what he meant was never admit to it. Yeah, that's a good point. Alan Jackson said in the trial that what went on, in other words, the witness intimidation, was vile. He used the word a couple of times. And he said, but that's not connected to us. That's not connected to Karen. I don't think so, Alan Jackson. I think it's very much connected to you. Why hasn't Bev ruled on the third party culprit? This may be something I don't, again, I'm not a lawyer, but so I think that maybe this is something that, well, she's going to, just like with the motion to dismiss, she's going to be very careful on this. So where was Nick last night? So, people are saying that Nick was afraid to come on or something like that. No, I'm sure it wasn't that. Court TV was a little tardy or very tardy. They were a little disorganized. Maybe some people were out or something. They took a while to reach out to me too. And then when they did, they didn't, when they even asked, after they asked me on the show, they normally send out an email saying who's on the show and what the topics will be. They didn't even do that. So I think they would just probably reached out to Nick or Nurse Kim or whoever, probably late. And it was, maybe they already had plans, but hopefully it's not because he has some other problem that he couldn't get on, but he's reliable. He's usually on there. So we're back on Court TV tomorrow. They did already send me yesterday the invite for that. So my guess is Nick will be back, but if it's not Nick, it'll probably be Nurse Kim. I don't know. That's there only two, right, at this point, but Barb says that TB was annoyed with Karen Reed. I've heard about this last night, that he was very annoyed with all the, see, I get distracted because I'm trying not to miss chat and I can't even, it's hard to even answer questions, but we're hearing that Turtle Boy was really upset with Karen because of all these interviews that she's done. And everybody in Turtle Boy's orbit has to stand. It's only a matter of time before he turns on you. Everybody. So he almost turned on Karen last year. Really at the same time. It was in the days leading up to jury selection for the first trial that Turtle Boy threatened because he was mad at Karen because he felt she was ignoring him. And then he was really mad when Karen had Nick in court instead of him because he didn't have a press pass at that point. And then he was mad that Nick was going on court TV instead of him. And he was so mad he threatened to bring evidence that he said would destroy Karen. He threatened to bring that to Lieutenant Tully. That's how mad he was. What kind of guy he is. And I'm going to guess that it seems to be building up to that again now. Why? Anybody, it's your guess is as good as mine. But has Karen cut him out again as she gets close to trial? I mean, even just being fair to Karen, you imagine the anxiety that she must feel right now, knowing that this trial is about to begin Tuesday and this whole process start over. So she may, even at the advice of her lawyers, have cut Turtle out, and he's pissed about that. We don't know, right? We don't know what messages might be found between her and Turtle Boy or her team and Turtle Boy. Those messages could be very damning. So there is a real chance that at some point they turn on each other and try to sell each other out. Turtle Slayer is here. Okay. Is the second trial going to be in the smaller courtroom? My understanding is yes. Yep, that's my understanding. Unless somebody knows other, they can tell me that. Yeah, if they put Turtle Boy on the stand, what's he going to say? He's going to plead the fifth. How does that look to your audience when you get up there and for the first time you're silent? You say, "I plead the fifth." Don't know. Is Turtle Boy worried at this point that Karen might be cutting a deal on him? Maybe. Yeah, he could work out a plea. Absolutely. Snow remover just got here. Have you discussed the hearing coming up about Karen and Turtle in front of Judge Siskis? I don't know if I can say that name. Sitsitsky. We discussed it. Yeah. So we don't know. This is this emergency hearing, and it's regarding. It's another step regarding those communications that Hank won the right to. But I don't know the details on it, and to our knowledge, it hasn't been scheduled yet. But it should probably be tomorrow or Friday. My guess is Friday, or possibly Monday. Carlton Fisk, that was one of my heroes as a kid. Karen will be ordering drinks for Canoni at sidebars. That's cute. So in the latest documentary, when Karen mocked John's mom, she said she said previously that she only looked at her like she did something, Good point, DJ. And now she's added to that story that there was a phone call and that um that Peg O'Keefe said, I think John looks like he was struck by a vehicle. You're right. Those are additions to the story. She's always adding to the story. All right. Any more questions, guys? There is Foghorn. There's an emergency hearing that should be coming, but it hasn't been scheduled yet regarding Turtle Boy's phones. Another meeting, another hearing on that. Sylvia, I had to hit this because I knew I was going to lose it because it was moving up and it was long. I missed last night. I think you mean on Court TV, right? And late as hell tonight. I did watch the retake, if you will. I support you in 1,000,000%, Kevin, and I freaking despise Turtle Boy, and I can't stand the whole crew. Yep. Thank you, Sylvia. Appreciate it. And so Krowski was a lot of fun as usual on Court TV last night. Okay, last call for alcohol, meaning last chance to send a question, and I'll be happy to take it on. I used to at the bar for many years. We'd be packed at last call. This was not the bar I owned. This was before that, a bar called the Blarney Stone. And I guess that's when I first had to learn how to raise my voice, but I'd be like, last call. And I yelled it out every night that I was working. And you could hear that. I learned how to make my voice cut through the crowd. Sylvia, thank you very much. Says, love you. And John O'Keefe supporters, Commonwealth supporters, thank you. We appreciate your support. All of us appreciate your support. Is she wearing headphones? Yes. Jeff Pogue says, I'll have a, I thought you said I have a Tito's vodka for the road, but he said, I'll have a Tito's for the soda for the road. Hey, you don't have to go home, but you can't stay here. Exactly. Yes, the Blarney Stone got closed down a couple years ago. Yeah, what happened was there was someone that was overserved and left, drove out of control, and killed somebody. Did I ever get a call for Al or AI? Alcoholic. Yeah, exactly. They have a Blarney Stone up there in Canada. Yeah, there's a few of them around. There was one in New York. I don't know if it's still there. Good name for a bar. And yeah, I think there is one in Boston. That's right. That's right, Joe. I do make the world's best. It's like riding a bike. It's been probably many years since I made one, but I wouldn't forget. Carol Farrington, if you want to contact me, my email is leitskev, LEITSKEV, @gmail.com. Wasn't the Blarney Stone in the sitcom? I don't know. I don't know that. Claire Marie, thank you as always. It's not necessary, but thank you. I appreciate it. I don't know that. Yeah, Bloody Mary's good anytime. The only thing with Bloody Marys that was bad with me is I like the taste of it so much that literally suck it down and it's gone in 2 seconds. And then you want another one because it's like eating peanuts or something like that. That once you start, you can't stop. So you can drink like 5 of those things in in like 20 minutes. But that's a lot of salt. And I was someone that don't add salt to a Bloody Mary. That was not part of my thing because you already had salt. Tomato juice is loaded with salt. Nick Rocco is doing a live now where tomato juice is loaded with salt. And but I would sometimes add celery salt to it, so that's even more. And then also, but you put Tabasco and Worcestershire. And Worcestershire is very loaded with salt too, so you're putting a lot of salt in it. So you got heartburn from that. I got heartburn from things like Mike's Hard Lemonade. I used to drink gin and tonics with lots of lime in it. I never got it from that, so I don't know. Jack D says he was at the Blarney Stone in Dorchester quite a few times. So yeah, there was a Blarney Stone there. Yeah. Colin says I'm starting to think she will walk away. I still have faith that she won't. There is no chance she'll walk. Well, if the case somehow gets dismissed on some with prejudice on some technicality, but that's unlikely. There's no chance that 12 jurors are going to quit. There's no chance. There's no chance of that. So I don't see, it may take another mistrial. I don't know. But if there's another mistrial and the prosecution has promised to continue doing it as many times as necessary. So Gene, thank you for the contribution. I appreciate it. Heather says she agrees. So what's not sure what she agrees with? She's probably agreeing with that there's no acquittal. What's going on with Mazda Media? I don't know. I've never watched Mazda Media. Actually, when I went to Dedham for the hearing this summer, I think maybe where they rescheduled the trial, I was standing with the blue shirts, and there was a crowd of like 500 pink shirts on the other side of this no man's land that that the state police patrolled. But I'm used to being in a hostile environment, so I walked into the pink crowd and started talking to them. And so LTL, who I had met once before in Dedham, so I knew him, he went live to interview me, and this tall guy did. And I was like, who is this tall guy? And people told me later that's Mazda from Mazda Media. I really had never heard of him, though. I've seen him since. I've seen like things on Twitter from him and stuff like that. So Mazda is not doing YouTube. Mike said give him privacy. So I don't know. I mean, hopefully he's had a pang of conscience. Who knows? Seems to be pretty rare in this case. Young Jelly had a pang of conscience, but after the mob turned on him and Turtle Boy threatened him, he fell back in line. All right, so I guess I'll finish with this. I've said before, say it again, since Turtle Boy's been posting on this today about the Ford Edge that Lucky allegedly saw. And now he's changing it to say it might not have been the Ford Edge. That the point is that he saw a vehicle there and that's suspicious. I don't know why he's changing it suddenly. That's really strange that suddenly after saying all this time that Lucky saw a Ford Edge sitting there with the lights out at 3:30, some reason Turtle Boy is saying, well, it might not have been a Ford Edge. Why is he bringing that up now? I don't know. But I have said that Lucky just might end up being a key witness for the prosecution because Lucky was confused on timelines and was confused on times, I should say, and, wanted to please, was possibly manipulated by Karen's private investigator. But he claimed to be out there plowing at 2:30 and 3:30. And as far as we know, we're looking at the weather reports, there wasn't enough snow to plow. In fact, you need about 2 inches to plow. And you had just about 2 inches at 5:08 when Karen is seen on the Ring video leaving. and it's snowing hard at that time. So it probably didn't start snowing heavy until about 4. So what was Lucky out there doing plowing at 3:30 or 2:30? It seems to be the case. Seems to me that he probably wasn't. He's just confused on that. But if he's confused on times, what else is he confused about? Now he asked. I'm sorry. He surprised Attorney Yannetti on the stand when he told Yannetti, "I last plowed the streets at 5:30." At 5:30, Lally didn't pick up on it. But when you look at the video of Officer Saraf, the dash cam video, it looks exactly like someone who had just come through half hour before and plowed basically twice. He goes up one side and down the other. That's all it looked like. So I don't think Lucky plowed at 2:30 or 3:30. That's my opinion. I believe he plowed at 5:30. And at that time, he saw an SUV sitting right in front of where John was with the lights out for some reason. So to the extent that you might be able to convince a jury that that's Karen, that goes a long way towards helping proving the second degree charge, because even if you can show that Karen went to the crime, even if they got GPS, for example, that shows that Karen did in fact go to the crime scene, that still doesn't prove that she saw John, right? But if she's sitting there, parked there with the lights out, you only turn the lights out if you're doing something that you don't want to be seen. That would be consciousness of guilt. But, admittedly, that's a reach. So, all right, guys, thank you for being here. I appreciate it. And if there is another hearing, we'll stay tuned and we'll certainly cover it. And there was so many motions and stuff that came out today. I gave you the most important ones. I don't think there was anything that I left off that was important, but we've had a really popular show on Friday here. So today is Wednesday. So I would expect that we'll be doing a show Friday. It's not impossible that we'll do one tomorrow if we get some good if there's some breaking news, right? Maybe I'll have breaking news when I meet with my oncologist and he says it's a miracle. Your cancer's gone. So if that's the case, I'm going to be on here to tell you tomorrow. All right, guys, have a very good night. Thank you for being here.